Your appraisal came in low. Now what? Before you panic or assume you can walk away, you need to understand exactly what your contract actually protects you from. Here's something that might surprise you. Even many attorneys and real estate agents don't fully understand the difference between a mortgage contingency and an appraisal contingency. And that confusion can cost buyers their down payment. First, let's talk about what an appraisal actually is. It's an opinion. One appraiser's professional judgment of what a property is worth on any given day. And more often than not, it won't come in at the exact sales price. That's normal. The real question is what your contract says when that doesn't come in at the right price. A mortgage contingency, which is what, by the way, most standard New York contracts contain, protects you if you can't get your loan funded in the amount specified in your contract. If your contract states you're applying for a $400,000 loan and the lender says the low appraisal means they can only fund $399,000, that shortfall triggers your mortgage contingency and it gives you the right to cancel. But here's where most people don't realize it's an issue. If the appraisal comes in low and the lender is still willing to fund the loan amount, a mortgage contingency alone does not give you the right to walk away or demand a price reduction. And honestly, think about it both ways. No one would expect a seller to demand the price be increased just because the appraisal came in higher than the contract price, right? So why would a seller be required to lower the price just because an appraiser's opinion came in low? The contract price is what both parties contractually agreed to. This is especially important if you're putting down a large down payment, let's say 40% or 50%. In that scenario, if the appraisal comes in significantly below the sales price, the lender may be perfectly willing to fund the full loan amount. Without an appraisal floor negotiated, you could be forced to close on a property at a price the market may not support with no way out. The only exception to this rule is an FHA or a VA loan, which have mandatory clauses that give buyers the right to cancel if the appraisal comes in below the purchase price. That's why before you sign, you need to understand what your mortgage contingency actually covers. Discuss whether an appraisal floor or an appraisal contingency as opposed to a mortgage contingency, whether that makes sense in that situation. Go in with the eyes wide open, and if the numbers don't line up, you'll understand your rights. Most people don't find out about this gap in their contract until it's too late. We make sure you understand every protection and every risk. Before you sign, give us a call.